Hello, everyone. 大家好. Very happy to welcome you all to this live webinar organized jointly by DFDL, DFDL Thailand, and Low Purpose in China to talk about what companies need to know to invest in the best conditions in Thailand and China. So today's agenda will be split between two parts, two sections. So we will hear first our colleagues from DFDL, Kraisorn and Jidapa, to talk about the main frameworks for foreign direct investments into Thailand. And then we will leave the floor to our colleague
Before we
jump right in. I'm happy to provide a bit of context about foreign direct investment framework. So to China, we are a Southeast Asian law firm, law and tax firm, covering 10 markets on the Southeast Asian region, including Thailand, of course, but also Vietnam, Indonesia, Cambodia, Laos, the Philippines, Myanmar, and Bangladesh. And we've been in business for 30 years this year, advising especially foreign investors coming to our markets on corporate regulations, M&A transactions, lending, setting up entities, tax issues, transfer pricing, and all sorts of corporate issues. And it's our very happy to have the opportunity today to do this collaboration with Law Purpose on this joint collaboration. You can see, yes, all the speakers on our side for today. Yes, without further ado, I'm happy to leave the floor to Kraisorn, who is our FDI partner in the Thailand office, who will speak about the framework for foreign direct investment in Thailand and the main corporate issues to be addressed.
Yes, thank you very much, Etienne, and good afternoon, everyone. My name is Kraisorn Rueangkul. I'm a partner of the FDL Thailand, and I'm happy to have a chance to speak with you about the foreign direct investment regime in Thailand today. So today's discussion essentially would divide into the introduction of the foreign direct investment law in Thailand, and then we will further discuss on options, exemptions that you may have as a foreign investor. Before we start getting into the detail of regulatory regime, I want to give you a bit of an overview of Thailand for your information. So Thailand currently is the third rank in Asia in terms of GDP per capita, and the growth is around 1.9%, which is still very relatively smaller than a lot of neighboring countries. But however, there's a lot of big push by the current government on the foreign direct investment. Therefore, it's I think it's still a good time and an opportunity for foreign investor to consider Thailand as one of the countries for the investment. Maybe a bit of information on the legal regime. We use the civil legal system, and general assessment. And in my experience, the legal system in Thailand, especially on the commercial dispute, is quite expectable and consistent in terms of the rulings. There are the publication of the Supreme Court rulings where it would set out the clear standards and criteria on interpretation of the laws. Therefore, in the commercial dispute, you would expect certain consistencies in dealing with the dispute in Thailand. So it's I think compared to a lot of countries in the regions, we are quite good at that. Maybe there could be an issues when there or challenges, I would say, when it comes to the cases or disputes that would relate to the political issues or the contract with the Thai government and so on. But in terms of private commercial dispute, I think that has been quite consistent. And I think the key strength in Thailand is that as it has been developed for many decades, so the infrastructure are relatively strong, and the government policy, no matter or regardless of changes in the country, either on the political aspect or on various things, one of the key things that all the government always maintain is that the very strong support of the foreign direct investment and foreign investors. So therefore, foreign investor could expect that there would be no sudden change in rules that could strongly affect the foreign direct investment so far in Thailand, regardless of the regime change or the political issues in Thailand. I think that's one of the key issues that I have seen so far. But of course, when it comes to challenges, there has been a political stability issues that has been ongoing for a number of years, almost 20 years already. But as I said, when it comes to these issues, and you may know that there are a lot of coup d'etats in the past many 2 decades. But what we have seen is that there is no effect in directly to the foreign investor. Simply an internal conflict politically between people in Thailand, and of course there may be some inconvenience, some issues in the city of Bangkok, but generally I do not think that it would affect anything on the foreign direct investment. According to the latest number, the FDI, in terms of FDI sources, it has been like this for many years. China has become a very strong investor in Thailand, and because of our long-term good relationship with the government of China, therefore, in the past 10 years, China has become basically the main source of FDI in Thailand, and Japan and USA would be another countries that have been investing in Thailand for decades. So the number is quite consistent in this sense for many years. When you look at Singapore, Singapore is basically a regional hub where all investors from all over the world will or may set up the subsidiary in Singapore for the purpose of investing throughout the region of ASEAN. Therefore, you could see that the number of investment from Singapore company are also relatively high. And when we divide the foreign direct investment amount by sector, you could see that manufacturing is also one of the important thing. A lot of investment in the foreign direct investment areas, 74%, a lot of them are services. So you can see that Thailand also becomes a good sort of international service provider who want to provide service in Thailand or in the region. And if we take a look a bit more on M&A transactions, you could see that healthcare has become a good source of M&A. The FDL has also participate in a lot of deals in that sector. I think in recent, in this couple of years back, after the COVID era, what we have seen is that the rise of the acquisition of real estate or hospitality project as well, due to the need of resupplying the rooms and the hotels because of the I think one of the key sector in Thailand are tourism. So we start seeing the resupply of the or consolidation of hospitality projects in Thailand. So healthcare, manufacturing, and hospitality, I think, is a typical one. What I have seen as well very recently, there is a sharp rise of interest and inquiries from transport and logistic companies, as well as the whole supply chain of electric vehicle. We received a lot of inquiry the past 2 years because the Thai government started to roll out a lot of incentive to the investor as well as to the consumers, so that I think in these coming years, because of the lack of the EV infrastructure in Thailand, we notice a strong traction in all the players in the supply chain of EV in Thailand. All those, of course, all EV producers or charging station service providers, battery makers, and so on. So the whole supply chain are being in. We have received inquiry even from the certification companies to test the standards of the vehicle and so on. So I think this is one of the key sector that could be quite robust in coming years in Thailand. So the next thing, before I move on to this, so maybe in Thailand, we consider the regulatory regime with respect to the foreign direct investment as a partially open, where the Thai government has set out list of business activities that are restricted to the foreigners. And then if your business fall under this list, then as a foreign company, you will need to obtain a foreign business license. Therefore, whenever we look at the foreign direct investment engagement, when we start working with you, there will be 3 key issues. First, whether your proposed business in Thailand would fall under any of the restricted list under the Foreign Business Act, right? And then second, in your particular sector, whether there is any sector-specific regulation that impose certain restriction on ownership of foreigners. Then another thing that we need to look is also that whether, even though you are caught by the restricted list of business activities, whether the Thai government provide any exemptions, either through the Board of Investment or Eastern Economic Corridor that we will discuss later on today. So these are 3 key issues that we always need to take into account when we deal with the foreign direct investment in any sector to Thailand. That's what I mentioned earlier. The list of restricted business activities are provided under the Foreign Business Act, and essentially there are 3 lists. List 1 is a no-no. So if your business fall under list 1, which is the essentially a national security or the business that are strongly reserved for the Thai, the traditionally reserved for the Thai, then you would not be able to obtain foreign business license. There will be no chance to as a wholly owned entity, foreign wholly owned entity to operate in Thailand. For list 2, is the list of business that the Thai government view that is a national security, but there will be a need for Thailand to open for foreign investment. So it less a degree of restriction on list 2. Essentially, if you want to operate the business in list 2, you need to obtain the cabinet approval. Is still high, but at least you would have a chance to obtain the foreign business license. In any case, from the information that I received so far, list 2 business, there is no track record of approval in list 2 business as yet at the moment, based on the information I have. So most of the time we're talking about list 3 business, where the foreign business license can apply, and you can simply obtain the foreign business license from the Ministry of Commerce. Basically, it's the process of merit consideration by the Foreign Business Committee, comprising of various representative from various governmental agency in Thailand to consider your project, whether it would improve the Thai economy, whether there will be any technology transfer to the Thai, whether there is a strong employment of a Thai employee. So those criteria will be used when the Foreign Business Committee consider the foreign business license applications. List 3 is quite important in a way that because one of the type of business that lists under list 3 of FBA is a service. So essentially, all kind of service will be caught under the Foreign Business Act, and there will be a need of a foreign business license. We will discuss in later slide on the list sample of the business activities that are restricted under the law. Maybe a bit more information on what is the risk exposure. So if you operate the business without a foreign business license, then you could subject to a fine up to 1 million baht. But what is the highest risk exposure is that there is a possibility that the management or executive of the company could also be subject to that fine. And I think the high risk is that there is a component of imprisonment as well that could apply to the management of the foreign company that operate in Thailand without foreign business license. And another thing that we will discuss later, further on in this presentation, is that the exposure concerning illegal Thai nominees. This is also and has become quite big issues in Thailand because we know that there is a heightened scrutiny and increase of the number of cases of investigation by the Ministry of Commerce or the Royal Thai Police on a potential illegal nominee in Thailand due to the in recent years there's a lot of foreign investor that use quite aggressive nominee structure to invest in Thailand, and we will discuss later on this issue. The next thing is briefly is that what constitutes a foreign entity. So essentially, foreign person that will be subject to the law is not limited to only a foreign company, but also a foreign person. So I think a lot of typical misunderstanding in Thailand, in my experience, is that a number of foreigners who live in Thailand with business visa, for example, they may want to enter into a consulting agreement with a company that they want to do the work for, but essentially it's not only work permit that you need, but you also is caught by are covered by this FBA as well in a category of service. So if you are a foreign person, foreign individual, you will be subject to foreign business license as well. And other foreign entity that are subject to this law is quite straightforward. One is those company that incorporated under a foreign law. Another are those Thai companies that the company which are incorporated in Thailand and have majority ownership being a foreign entity. One of the typical issue that we advise a lot is when will the law, this foreign business law, will apply to you. One of the key element is that you must have a business activity on the ground in the territory of Thailand. And the criteria in our experience working with the Ministry of Commerce is that if let's say you are a foreign company, you enter into contract with a Thai company or foreign company, but the work must be performed in the territory of Thailand. If you send employees to work in Thailand, you will be considered as carrying on the business in Thailand, and it would trigger this law. Another typical one that not many people would know is that if you have a master contract, you are a foreign company, you have a master contract, there is a local portion of works to be performed in Thailand, and you subcontract that work to a Thai company to work on that. Ministry of Commerce has been consistent in their position to view that that subcontract would be considered as well that you are carrying on the business in Thailand. So the master contractor who subcontract those work to Thailand could be subject to foreign business license requirement as well if your business activity falls under any of the restrict lists under the FBA. So that is why there will be a need of careful structuring that we often help our client to ensure that you could navigate this. You still have a contract with the client, but you can also have a local portion of work being done by your subcontractor without being subject to this foreign business license requirement. Okay, so this is the typical list of business activities that are not part of the restricted list under the FBA. The most typical one and used quite often is that if you simply set up a company in Thailand to invest in any company in Thailand, you will act as a holding company. In that case, you can do it. You can simply set up a company and do that business activity directly. Another typical one is also manufacturing. So if you do manufacturing, then you are fine. You can operate in Thailand at any time, right? So that I think one of the most used exemption that I have seen. And another interesting one that I would want to flag is that there's a lot of trading companies that interest in either engaging in wholesale or retail in Thailand. That's a good exemption as well, is that if your initial capital injected into Thailand, let's say you set up a company with 100 million baht registered capital, then you can engage in either wholesale or retail business right away. But if you want to do both, then you need at least a minimum of 200 million baht to do so. There's a small restriction for that, is that for wholesale, you need to have only one point of sale. And for retail, you can have only 5 point of sales. And for those online operators, Ministry of Commerce has viewed that online channel is considered as 1 point of sale, just for your information. So this, we have helped client on this to take advantage of this exemption as well. In my experience, normally you would start with a distributor in Thailand, and once you know that your inventory would reach around this amount, then you can take advantage of this exemption and set up a company. It may not be suitable for those who want to test the market in Thailand, but yeah, I have seen big players take advantage of this exemption quite often. Maybe another area that are quite popular in the past 10 years, but right now it maybe stagnate a little bit, is that the power producers are also one of the type of business that is exempt under the foreign business law. So if you are and the minimum capital requirement for all kind of investment in Thailand are quite small. It's only 3 million baht, roughly around 10,000 USD. But in any case, if you apply for foreign business license, the Thai government would want to see your estimate investment amount and capital expenditure, and they usually will use that amount of expenditure as minimum registered capital when they consider your application. So even though the law said that minimum must be 3, but it could be higher. And another key component is that if you operate in many type of business, please note that this minimum capital requirement is only for one type of business. Let's say if you have 5 type of business, then you need 15 million baht. And just to ensure that we have a lively discussion, and if you have any query, please feel free to drop your questions, if any, in the Q&A box, and then ATM here, our moderator, will stop me, and then we'll ask questions as we get along.
Kraisorn, maybe I was thinking, in the interest of time, we could jump in the investment promotion schemes and some of the JV structuring options for foreign investors.
Okay, I agree. Maybe just to give you, basically you can look up quite quickly. After this, we will make this presentation available, but the list of restricted business will be clearly set out in the Foreign Business Act. Okay, and I will discuss briefly, because this is another key component. Other than the list of business, even though your business list as a restricted business activities, but we always recommend, and we will help our client to identify whether there are any exemption under Thai law that you can take advantage of. The key one is the board of investment, which will list out type of business that the Thai government currently really want to support and promote. And basically, it's a list of business that the Thai government want foreign investor to come into Thailand. In that case, you can apply with the board of investment that we will discuss after this. But another source is the international treaties that the Thai government have with the foreign government. The typical one is the US-Thai Treaty of Amity, ASEAN Treaty, and a number of things. Okay. This has been, when it comes to foreign direct investment, is always the first place to look at the board of investment promotion. This is because we briefly discussed about the foreign business license application is, to me, is considered as a case-by-case consideration. So it's based on merit, and it's quite unpredictable. But if the board of investment, if your business falls under any list of promoted activities, it means that you have a full support of the Thai government if you can comply with the project condition and so on. So this is, to me, is a qualification based application process. That if you qualify, you can operate in Thailand. So this is always the first place to look at whether your proposed business in Thailand qualify as a promoted business, and then if that is the case, then we discuss about the project condition. If you can comply, then you can operate in Thailand quite easily. Not only that you will be exempted from foreign business law, but you will may also get incentive by the Thai government in doing so. Typically, the conditions that the BOI will set out is that it must be a new project. The debt to equity ratio must not exceed 3:1. They always tend to support the new machinery use, and with certain type of investment, there could be an environmental measures and also feasibility study would be required. The privilege that I just discussed, I think one of the key thing is that you could have tax holiday. You could also get the exemption on import duty, and you have the right to use the law to be carried forward in the next fiscal years. And also there will be tax privilege based on the area that you invest in. This is to encourage the foreign investor or any investor to invest in certain targeted area that the Thai government want to support. But I think non-tax incentive are also very useful under the BOI regime. One of the key interesting privilege is that the BOI promotion holder can also apply for the right to own land, which is not generally available to foreign investor. This is very useful. In any case, the size and the location of the land must be reasonable when considering the activities of the foreign investor of that foreign company. And it's interesting to note as well that this right could include also for the right to own accommodation of the executive, just for your information. Maybe this is a bit of operational details. Okay, so I want to give you a broad expectation because a lot of clients may reach out to us when they want to launch certain thing very soon. Please note that foreign business license generally could take around 6 months. This number 6 to 8 months, we witnessed it during the COVID year because of a lot of officers are working from home. Now I think the period is quite improved. We're talking about, let's say, 4 to 5 months, but in case that the project is new, the type of business is new to the officer, then there could be a lot of back and forth development of application with the authority to pass the project. BOI certificate used to be 4 to 6, but right now I would say it around 3 to 4 months. Sector-specific license is quite varied and depending on the sector you are in. Some can be quite fast, some can be quite slow. For example, I know that license concerning banking sector or security sector could take very long time in working with the regulator to obtain the business license. Maybe I just briefly discuss this because our audience today may not be able to utilize this, but the Thai government have a treaty of amity with the U.S. government where it set out that U.S. majority owned can operate any business in Thailand except for reserved ones. This has been used as an investment option for those international companies, regardless of their nationality of origin, in the case where they have quite strong existing operation in the US, where you can basically do certain structuring and then take advantage of this amity. And then I will skip this. This, the most recent one, Eastern Economic Corridor, which has been in operation for a couple of years now. It's basically a additional incentive, but the concept are pretty much similar to the BOI, where they will list out the type of promoted activities. The key difference is that EEC is the business promotion that created only to the certain area in Thailand, which is a eastern part of Thailand, in Rayong, Chachoengsao, and Chonburi, where if you operate in this, you will get BOI, and you could get additional incentive because the Thai government really want to promote this area. And the government also set out the sector that they really want to support. For example, those smart technology, smart warehouse, international distribution center, or aviation, automotive. So they set out the list of promoted business that they really want to attract foreign investment into this area in Thailand. I think the last one is which are utilized by a lot of manufacturing companies, is the Industrial Estate Authority of Thailand. This is not generally not the exemption, because manufacturing is already exempt under the foreign business law, but it give this industrial estate basically give the life of the foreign investor much easier, because the concept is that they consolidate all of the license and permits into this one single authority. And then if you operate as a manufacturing company in this zone, we call industrial estate, register with this IEAT, then you can basically apply almost all of license and permits for your operation with this single authority. It's quite give a lot of useful convenience to the foreign investor. And another thing for this is that it could also have the right to own land. So you, as an operator in IEAT, you can own land in the IEAT zone. So that's a good incentive to be part of the or operate in the Industrial Estate Authority zone.
So that answers one of the questions we received from the crowd, which was asking, can I if I set up a 100% foreign owned company, can I buy industrial land without the BOI license, basically?
Correct. Yes, you can. Same concept, proportionate with your proposed business. Joint venture with a Thai partner, it has been one of the key investment options for Thailand many years, but I would want to give big cautions, because the enforcement environment has changed quite significantly. The Thai government start to look at this more carefully, because essentially is an criminal offense to have a Thai person hold shares for you. The illegal nominee essentially is that basically the Thai person just hold share for foreigners, and how the DSI or the Royal Thai Police look at this. We have seen the manual a couple of years back on how they want to look at the structure of the company to consider whether there is an existence of a illegal nominee arrangement in a company. Because why I want to raise this as a quite significant issue, because we noticed that if you work with certain advisor that may familiar with the overall, where everything you can do everything, and then you expect every authority will turn the blind eye, I think that era is a bygone era. You need to look at the structure more carefully and consider whether the proposed arrangement would have any existing exposure in this, even though it's a genuine investment. Right? So based on the information we have, the DSI set out certain issue that they consider as a illegal nominee profile. What I would say is that for those issues that I mentioned here, in itself is lawful. But when the authority they will look at all the indicators. The more the company have this type of risk exposure, the higher chance it gets that the authority may launch an investigation on the company. A typical one is the class of shares, where basically you, under the Thai company law, you can gain effective control on the company, even though you are a majority by having a preference share arrangement where effectively you, as a let's say 49% minority shareholder, you can have 60% or let's say 80% of the voting rights over the majority Thai. So this has been one of the issues that they will take a look on this. And also the nomination right of the management is one of the issues that they can take a look on this, whether a minority foreign shareholder have the total right of nomination in the board of over the board of the company. And another typical one that I work with the client a lot is also on the sort of fund. The authority could also look at whether the Thai, and this has been one of the key issue that we discuss a lot when we do the structuring advice for the client, is that your Thai partner, if you want to have any, that person should have an investment experience or should have an experience in the sector that this company will be engaged in. And that person should have his own financial capacity to invest or subscribe for shares. If the person want to take loans, it should be loans from a third party, not directly from a foreign shareholders. I think this has been one of the key thing that very important when you want to find a Thai partner to operate the business in Thailand. I forget to mention that the reason why that joint venture with the Thai company is very popular option is because you don't need to apply for any license with respect to the foreign business. That you could see that it take quite some time, either 3 to 4 months or 6 months. But if you have a Thai partner, basically you just set up a company, and the company can be set up quite quickly, which is like in 2 or 3 weeks. But normally the time consuming part is the negotiation and discussion over a joint venture agreement. Yes, this is what I mentioned on sort of fund and sort of working capital. So if the Thai get the fund from the foreign shareholders, this could be one of the risk factor that the authority will take a look whether to launch the investigation on the company. Another thing that they would look is also that the flow of dividend payment. If dividend never been paid to the Thai shareholders, or if it is paid and then it's rolled out back to the foreign shareholder, that is also one of the risk area that they think that, okay, this could mean that Thai shareholder has no financial benefit at all for the shareholding, which is quite unreasonable. So the investigation could take place. Financial capability of Thai shareholder, we have discussed on that. So the penalty is would apply to both the Thai shareholder is himself or herself, and also it could apply to the foreign shareholder. And not only that, it would also apply to anyone who support this arrangement. So it could apply to, again, all the executive involving in the creation of illegal nominee arrangement. Therefore, it's very important issue when you want to take Thai partner options, that you must carefully structure your company to ensure that you will navigate these risk factors that we discussed. Yeah, the typical one is 5149. And with the next slide, please, we can show some example. Yes. So as I mentioned, the risk factor that we discussed previously in itself it's legal. Therefore, if we those preference shares, different voting right, the right of nomination can be utilized, but utilized to the while maintaining the reasonableness and clearly display the active involvement of the Thai shareholders. Essentially, you can use preference shares to have a vote, but also the Thai should be on the board, and the Thai could have certain reserve matters that the party must be agree on very important issue, and the Thai shareholder can give the rest of the other issues under the control of the board that are majority appointed by the foreign party. So essentially, those risk factor you can use, but use it in a reasonable manner. This is a typical structure that we have seen in the market when you want to do a joint venture option. It doesn't have to be this percentage, but this is a typical one, which will make this company as a Thai company rather than a foreign company if the Thai hold at least 51% majority of the company. These are another typical one where essentially the key difference is that you put the relationship between the foreign partner and the Thai partner at the holding level. The advantage is that whatever dispute you may have, it will have at the level of the holding, and it will not directly affect the operating company down below. That's one of the key benefits of having this structure. And another advantage of this structure is that each level of shareholding, the foreigner can have 49% shareholding, whereby you will receive the dividend already at the opco level, and then again at another level. We have seen multiple tier, even more than two, for in this type of structure, so that it would the foreign majority foreign partners can have a lot more share in the dividend, in the flow of dividend payment. The last issue is just that there are a concept of what we call representative office. Essentially, if you have yet to know the Thai market fully well, or you have existing business in Thailand, let's say you have a trade to the Thai partners, and then you want some local activities, you may look at representative office as one of the options. Essentially, it's a branch that's simply set up for helping the headquarters in, for example, in conducting market study, in disseminating or providing information on new service or new product that the headquarters has, or in helping the headquarters in working with existing customer to ensure the quality assurance, or in case that you have Thai supplier, you want to ensure that your supply are in good shape, in good quality, then you can use this type of entity to operate in Thailand. The key thing about rep office is that this entity cannot generate any form of revenue in Thailand. You are simply a supporting office to help the headquarters. So all the expenditure and fund being used in Thailand must be funded by the headquarters itself. And you cannot generate anything. So you are not allowed to engage in any contract negotiation on behalf of your parent company and so on. This has been quite useful option for those companies that want to understand the Thai market or having existing supplier or customer, because this could help facilitate the work permit and business visa of those who you want to put in Thailand to work on those contacts that I mentioned. Yeah, this quite straightforward. It's a minimum 3 million baht and then you must inject the capital for 25% within 3 months, and then complete the capital contribution within 3 years. Very briefly on land, we have discussed land is not allowed to be owned by a foreign entity. Interesting issue is that land cannot be owned, but you can own the building. Therefore, in the real estate deals, there could be a structuring option where you can own the building and then lease the land. The lease under Thai law is allowed only 30 years, but based on the Supreme Court ruling, is recognized the renewal option, fixed renewal option or automatic renewal option. Therefore, technically speaking, the rental period permissible by law could be up to 60 years. Yeah, and if that land qualify or your project qualify for a commercial activity or industrial activity, you can take advantage of the law to increase the rental period to be 50 years, and then you have automatic option, right? In that case, you can be, let's say we're talking about the rental period of up to 100 years. And the last issue is on foreign exchange control. I think the good thing about investing in Thailand is that we have quite a liberal foreign exchange rules. So essentially, all the money coming in are quite easily to be in. And when you want to pay certain thing outside of Thailand, let's say a dividend or any commercial expense that you engage a foreign counterparts, is quite freely done. And the system is that rather than you need to seek for the Bank of Thailand approval on financial transaction, essentially the law set out that the Commercial Bank of Thailand are the gatekeeper to check, to KYC you, to understand you, and also to flag in case that or request for more information about the transaction that you are in. Let's say if you want to do the dividend payment, then you simply give the list of shareholder of the company, and then sometimes they might need a minute, but just provide the evidence that you are a shareholder of the company, and then you can simply transfer it. You don't need to seek for approval. Your bank relationship manager would just simply ask for a copy of document, and then you can do the transactions. Similar to also to the normal commercial expenditure that you can just give, maybe your bank simply request for a copy of contract or invoice, and then they will give clearance to that transactions. Only certain big transaction or unusual transaction that list under the law that you may need to get an approval from the Bank of Thailand. But in my experience, for those companies that have international transactions as well as dividend payment, is quite straightforward in Thailand. And that's pretty much it in terms of a very brief introduction to the foreign direct investment in Thailand. Please feel free to let me know if you have any questions.
To leave the floor for a few minutes to our senior tax advisor, Jidapa.
Hello, my name is Jidapa. I am a senior tax advisor at DFDL Thailand. So today I'll be discussing about overview of Thai tax. The first thing we'll talk about is corporate income tax in Thailand. The corporate income tax in Thailand is 20% on net profit. There is no separate capital tax gain in Thailand. Capital tax gain will be included in the net profit and subject to normal 20% corporate income tax. However, the corporate income tax can be reduced or exempt if the company receives Board of Investment certificate or tax benefit provided by the Revenue Department. Thailand does not have any thin capitalization rule, meaning that there is no limitation on the deductibility of the interest expense as long as the interest expense is related to the business operation in Thailand. However, if the company receives Board of Investment incentive, it is subject to debt to equity ratio of 3 to 1. Thailand has a transfer pricing rule where it requires that a company with an annual income of 200 million baht has to file disclosure form to disclose all of its intercompany transaction to the Revenue Department. The next one will be VAT or VAT. VAT is imposed on the sale of goods and provision of service. Like in other countries, Thailand VAT rate is 10%. However, it is reduced to 17% for several years. The reduction is generally extended on an annual basis. VAT is calculated by input VAT minus output VAT. I think it's like similar to most of country. In Thailand, if input VAT exceeds output VAT, the excess amount of our input VAT can be carried forward indefinitely, or you can request for a refund. But if you request for a refund, please note that it will trigger tax audit automatically. Export of goods is subject to 0% VAT. Import is subject to 7% import VAT, which will be treated as input VAT for VAT calculation purpose. When the company registers for VAT in Thailand, it will be required to submit VAT return every month, regardless of whether there is VAT payable or not. So if you don't have any VAT payable, you still need to submit a new return anyway. For withholding tax, any payment made from Thai company to Thai or foreign company is subject to withholding tax. But in this seminar, we will only discuss about dividend made to foreign recipient. Withholding tax rate will be based on type of payment. For dividend, it will be subject to 10% withholding tax, but while other payment, including interest, royalty, service fee, and capital gain, will be subject to 15% withholding tax. The withholding tax rate could be reduced or exempt under the double tax agreement between Thailand and the country of the income recipient. So in this slide, we'll talk about the double tax agreement that could potentially reduce withholding tax rate between the Thailand and China or Hong Kong. Fortunately, Thailand has DTA with both China and Hong Kong. So here you will see the comparison between domestic Thailand withholding tax rate and withholding tax rate under DTA between Thailand, China, and Thailand, Hong Kong. For the dividend, there is no reduction, so the rate will be normal to domestic rate at 10%. For interest, there is a reduction for both China and Hong Kong, which the reduction only apply to payment made to financial institution. So in other case, like the loan between related party will still subject to 15% withholding tax. And for royalty, under Thai-China DTA, there is no reduction, but for Hong Kong, the reduction depends on type of royalty payment. 5% is for anything related to copyright of literary, artistic, and scientific work. 10% is for a royalty payment related to trademark, design, patent, or secret formula. And if there is other kind of royalty, it will be subject to normal 15%. For capital gain on sales of shares, no exemption or reduction for China, but there are exemption for Hong Kong. If the value of the shares, 50% of value of the share is not derived from immovable property situated in Thailand. So in this case, if Hong Kong Thai sells its shares and the value of shares in Thai company is mostly like more than half, 50% derived from immovable property like factory, land, house, condominium, or anything immovable property, it will not, capital gain tax will not be exempt in that case. So DTA with both China and Hong Kong provide exemption on business profit, which would generally include service fee. The application of DTA benefit in Thailand is automatic. It means that you don't need to request for approval from the tax authority before relying on DTA benefit. While in many countries, like Indonesia or Myanmar, it requires that a company making payment need to submit an application and receive approval from tax authority before adopting the DTA rate. So this is more convenient in Thailand in terms of applying DTA benefit. So in this slide, I will be discussing about International Business Center, which is tax incentive provided by Revenue Department. Is very popular one, like in this day. And International Business Center or IBC is a company that provide qualified management service or treasury management to Thai or foreign affiliated company. The Revenue Department provide tax incentive for this kind of company, which include reduction of corporate income tax rate and withholding tax exemption on certain payment, including dividend. So these two major incentive make it very popular. In order to qualify as an international business center under Thai Revenue Code, the company must have paid up capital of at least 10 million baht and providing qualified service to an affiliated company in Thailand or offshore. The qualified service include management, technical, and support service or treasury management service. In addition to that, the company must have 10 knowledgeable or skilled employee and incur local expenditure paid to recipient in Thailand of at least 60 million in each accounting year. The reduction of CAT rate will depend on the local expenditure paid to recipient in Thailand. So we'll be discussing about the tax benefit here. The corporate income tax, the company qualified for IBC will receive corporate income tax reduction from 20% to 8% if it has local expenditure of 60 million and 5% if it has local expenditure of 300 million and could be lowest to 3% if the company has a local expenditure of 600 million. The company also granted CAT exemption on dividend income received from its affiliated company in Thailand or overseas. And when the IBC company pay dividend to foreign company, is also receive withholding tax exemption. So most of the dividend flow will be exempt if in both way, like in or out. In addition to this tax benefit that benefit to the company, it also provide tax incentive to personal to employ the foreign employee working for IBC. General personal income tax rate in Thailand is progressive rate between 3 to 35%, but for foreign employee working in IBC, it will be subject to flat rate of 15%. So IBC is a good choice for a group company that has subsidiary in Thailand overseas. It can provide back office service to subsidiary either like in Thailand or overseas. And subject the service income received from the back office service will be subject to lower tax rate here. This is benefit for the company with number of subsidiary and would like to restructure its back office service and move it to be under IBC in Thailand. So that would be all for tax part. So if you have any question, please put in the chat.
Thank you so much, Kun Jidapa and Kun Kraisorn. Now, very happy to leave the floor to our friends and partner, Jin Feng from Low Purpose. Jin Liu, very happy to have you, and we look forward to listening you on foreign direct investment and the regulatory framework in China.
carrying in and going out. And now we can also see a lot of like the data shows that the whole investment in China is also very good. For example, many foreign companies, they are trying to make China their biggest market in the world, and also we can see that trend is very good. So today my topic is about investment in China, opportunities, challenges, and legal issues. We are going to have an in-depth analysis of the complex environment of the investment in China and the coping strategies. And I also see that we are going to have their agenda today. So the first topic is about why we are going to have some investment in China, what kind of the challenges we will face, and what's the investment opportunities for us. It's also very important why so many foreign investment companies, they will come to China. So the second part, we are going to share some key legal issues for investment in China, especially that the Chinese government is releasing the 24-point action plan to encourage the investment. And basically, we will have like a really very interesting comics about the foreign direct investment. So basically, the company will have like their own business in the home state. For example, we will have like our original company in Thailand, and also we want to explore more of the market in the world. For example, we are going to create a company and build a new company in China or as like a host state. It's often like some different parts in the world. And the common FDI sectors, it will include like electricity, gas, water, mining, agriculture, manufacturing, financial institutions, hotels, restaurants, and constitutions. And these kind of like different sectors that we are talking about now will also have some clues with our 24 action plans later. So when we are talking about the challenges in China, here we are going to talk about like 5 parts of that. The first one is the regulatory complexity, because we are like going into a different country like in China. We have our own regulations, permits, and license. For example, some publishment and some cigarettes are not like they need some special license to do that work in China. Also, the second part is about the market access restrictions. We have to understand that there are some specific sectors restrictions in China, and we will have some deep analysis later. The third part is about IP protection. As we know that the IP you need to apply from different regions or the countries. So how will China protect the IP, especially on AIGC, differently from China and some other countries' original home state is also very important part. The fourth part, we are talking about the market competition. How will we deal with the intensive competition in the Chinese market, not only within the Chinese companies, but also with the foreign companies? How can we leverage and manage that kind of competition? The fifth part is about culture and language barriers. As we all know that the cultural difference is very important for us. I can give you a short example that, for example, the Japanese company Sony, they just make a post that they will have a new camera on the website and on the media of the Weibo on July 7th, which is like a special day because there are some different things about the World War II between China and Japan. And now that kind of advertisement is fined for 1 million RMB. That is crazy, but we have to understand the culture and the language barriers to make our foreign investment more better in the Chinese environment. But also we see the challenges, we can also see a lot of opportunities for investment in China. For the first part, we have the very large, vast consumer market potential. We have 1 billion and 4 million population in China. China boasts one of the world's largest and the fastest growing consumer markets. We have presenting the significant opportunities for investment and market expansions. As I said before, China market has become a lot of like foreign companies, their first market in the whole world. Even the Apple, they are carrying a lot, focusing a lot on Chinese market. The second part is like we have the opportunity because our government have a lot of support for innovation and technology. As we all know that Alibaba, Jing, TikTok, these kind of like high tech and high innovation companies in China are boosting now because our government are supporting and financing them. We also welcome the foreign companies to come to China to create and foster the technology development. And in the 24 action plans, we can also see some policies and financial support in this regard. The third part is about the rapid urbanization and the infrastructure projects. As we all know that we have the One Belt, One Road, the project. We are also maybe have some railway, highway train from China to Thailand to other countries nearby. We are making a lot of like infrastructure projects to create a lot of investment opportunities for the whole world. And we also want foreign companies to join us in this part to help us on this side. The last part is about the central role in the global supply chains. As we all know that Amazon has one of the biggest supply chain in the world. They are delivering goods from the China to the world market. And also we have some e-commerce market platforms such as the Taobao, such as like the Jingdong, Shein, Temu, like this kind of e-commerce part. They are also playing a very pivotal role in the global supply chain, providing opportunities for business and seeking for the international expansions and marketing diversifications. And now it's very important for us to understand the legal aspects of the investment in China. So basically, we are going to share about the 6 parts of that. The first one, we will talk about some foreign investment regulations to understand the market access restrictions and the regulatory compliance. The second part is about IP protection to safeguard the IP rights through the legal frameworks and enforcement. The third part is about the labor and employment laws to comply with the labor regulations and employee rights within the Chinese laws. The fourth part is about corporate governance and compliance, that we have to adhere to the corporate governance and standards like compliance regulators under the Chinese government requirements. And the fifth part is about taxation and customers regulations. We have to define and identify the investment opportunities, like where parts we have some more tax preference, like in this part. The sixth part is about dispute resolution mechanisms. How can we use the effective mechanisms for the legal disputes? And here now we are going to show you a data about published by the UNCTAD in 2024 January. And for the first line, that in the green line, we can see that the FDI in the world is like they decrease like 18%, which means like for the whole economy, it is not that good for us. However, if you take a look at the Asia, it's like decreased by 12%. It's still okay. For the China, it's decreasing by 6%. So basically, China also has a very boosting market to attract these kind of foreign investments. And Chinese, under this background that we are going, the Chinese government, we issued a 24-point action plan to attract more foreign investment. We want to promote more high-level opening up and also facilitate data flow and business travels. And for the key parts of the 24 action plans, we are going to break down it into 4 parts. On 28th February this year, the State Council issued the action plan for solidly promoting high-level opening up to the world and making greater efforts to attract the foreign investments, which we call the 24 action plans. It's also about the 4 parts. The first one is about the expanding the market access, that we want to attract more foreign investments into us. The second one is about the increased policy efforts. The third part is about optimizing a level playing field, that we want to make the foreign companies, they have the equal treatment as the Chinese companies as well, so that we can attract more investment in the future. The last part is about progress by innovation and improve the regulations. And we will have some deep analysis on that each by each. And for the first part, we are talking about on the legal side is like how we are going to navigate in the foreign investment regulations in China. We have to understand the laws, regulations, and market access. So basically, China has specific laws and regulations governing foreign investments, including some restrictions on foreign ownerships in certain industries and the requirements for the establishment for the foreign invested enterprises. For example, if you want to conduct some specific areas like related to the safety, to the data, map data, like these kind of things, they are really sensitive to the China government, and they are restricted. And also, if you want to try some medical devices, sometimes it were limited. And we are going to see some new trends by the 24-point action plan. And from the second one is about the market access restrictions. We will have some restrictions vary across sectors, such as telecommunications, because you are controlling the mass media to have some process on that. And also from the finance, media, healthcare on this side. Basically, we want some joint ventures with local partners to conduct these kind of specific areas in the industries. For the first part, we are going to talk about the expanding market access. We are going to have the 4 small parts of that. The first one is rationally, we are reducing the negative list for foreign investment access. We want to improve the management system of the pre-access national treatment, plus negative list for the foreign investment, comprehensively abolish some restrictive measures on the foreign investments across access in the manufacturing sectors, and continue to push forward the expansion and of the opening up in the telecommunications, medical care, and some other fields. For example, in the past, we have 2 restrictions in the manufacturing sectors. One is that if you want to create some publishment company, you have to join you have to create in a joint venture. The second part is about the production of the Chinese medicine. So that in these 2 kinds of like area, it is like restricted by the foreign investment list. And now with the 24-point action plan, we are removing the barriers and totally open the manufacturing sectors. It is open to all the foreign companies now. And second part, it's about carrying out the pilot projects to liberalize the access for the foreign investments in science and technology innovation. And we have some, as we all know, we have some pilot free trade zones in Shanghai, in Beijing, in Guangzhou. So basically, we are going to have a new measure to allow this pilot-free zone to select some numbers of the foreign investment companies to carry out some pilot projects to expand the opening up areas in order such as the gene diagnosis and the treatment technologies. So in the past, these kind of areas are totally forbidden for the foreign companies. Now we are going to open the door little by little, step by step, to have a try at that first. And I do believe that in the future, we are going to open up more, but we are just taking the steps small by small. And on the second part, we are going to supporting the opening up initiatives in areas such as information service. It's only limited to the app stores, not included the website stores, to better materialize in the pilot free trade zones. So the foreign companies in the pilot free trade zones, they will have to have some innovation services to try on the more innovations to and also to facilitate the science in the medical areas. The third part is about expanding access for the foreign investment financial institutions in banking and insurance. We are going to support the foreign funding institutions to conduct bank card cleaning business in accordance with the law and under the permissions of safeguarding the security, efficiency, and stability. We are also going to deepening the liberalization of the commercial pension insurance. and health insurance and other industries to support to qualify the companies to investment and participant in the insurance like the industries. This is also very good for us to know more about the these kind of policies, nice things. And the first part is about expanding the scope of the participation of foreign financial institutions in the domestic bond market. We are going to optimize the procedures for foreign bond financial institutions to participate in the domestic capital market and further facilitate the participation of the foreign fund financial institution in China's bond market. And also, we are going to support the foreign bond financial institutions to participate in the domestic bond underwriting in accordance with the regulations. So basically, we are regarding the market access areas, we are taking some new steps trials. For example, in the pilot free trades to have some new tries, and also we are removing the barriers for the foreign investment companies in their manufacturing industries, and taking some more insurance industries as well. And we are going to have the second part about the corporate governance in China. We are going to see how we can compliance with the Chinese corporate governance standards and adhere to some shareholder rights, bond communications, financial reporting regulations. And also we are going to share something about tax obligations for the tax investments. And we are going to see some tax preference policies as well. So basically we are the second part about the 24 action plan is about to increase the policy efforts. So the first part is that we are expanding the category of the industries, encouraging foreign company investments and the list of the foreign investments. For example, we are going to support the advanced manufacturing, high-tech, energy saving, these kind of like industries to encourage more foreign investments and increase the basic manufacturing and applicable technology. Also, we are going to actively support the projects invested by the foreign companies on the biomedicine, high-end equipment, and other fields in the list and key foreign investment projects. We are basically encouraging these kind of innovations and these kind of like industry, high-tech, like these kind of things to promote further progress of the society. And second part, we are going to implement some tax support as well. The projects invested by the foreign companies in China, they can enjoy the policy of exempting tariff on imported equipment for self-use according to the new law. So this is like a huge difference that if you are for the self-use, it can totally be exempted from the tariff. And also if you are going to invest the companies in Hainan province and some western part province in China, they are going to lower down the tax rate from 25 or 20%, depends on the company type. It will be lowered down to 15%. It's also a tax support policy from the Chinese government to attract more foreign investments. Also, we will have some preference tax policies for foreign investors investing in Chinese bond market and some other financial markets. That's the second part about the tax support policies. The third part is about we are going to increase our financial support. We are going to encourage financial institutions to provide high quality financial services and support to qualified projects. That's one thing. Second, we are going to support the foreign invested entities to issue RMB bonds in China market and use them for the domestic investment projects. It's also a big progress for us to issue RMB bonds. The third part that we are going to promote the implementation of the policy facilitating foreign exchange management for cross-border trade and investment. This is also very important for the exchange management because sometimes we used to have to limit, and also now we are going to promote that and provide financial support for the foreign companies. The fourth part is about strengthening energy consumption securities. And we are going to improve the regulation of total energy consumptions and incentives, focusing on controlling fossil energy consumptions. For example, we are going to exclude raw material energy use and non-fossil energy use from the total energy consumptions and the intensity control. The second part is that we are going to accelerate the promotion of green certificate trading and interprovincial green power trading. For example, as we all know about the carbon neutrality project in China, we are going to have a try like whether we can trade on the green credits, so that like basically foreign companies, they are doing better on ESG side. So maybe the market or the Chinese company, they can buy from the foreign companies for the ESG credits, for the green credits, and we can create a trading market in the future to strengthen the energy consumption securities in the future. As we are going to talk about like this kind of like foreign companies and domestic Chinese companies, when the foreign company making an investment, they are thinking about whether the cost benefits, what's the cost, what's the benefits, and also what's the international investment treatment on that. So we are going to have some policies to optimize a level playing field, because the foreign companies, they used to have a lot of like discriminations and barriers from the government. For example, if they are going to doing business with the public universities, public hospitals, and public enterprises or state-owned prices, they have to go through the bidding and the tendering system and procedures. Sometimes these kind of like public things, like or like the state-owned companies, they will set some barriers against the ownership of the bidding things of the entities, and also they have some. The Chinese companies sometimes may take advantage of these kind of like bidding and tendering systems as well. So we are going to, the first thing is to clean up the behaviors and the policy measures that violate fair competitions. We are going to promote more things to encourage more foreign companies. Promptly, we will deal with the discriminatory acts against the foreign invested enterprises in government procurement, bidding and tendering, qualification, licensing, standard setting, and enjoyment of the subsidies. These are the discrimination acts, and we are going to clean them away step by step. Second part is about accelerating the formulation and introduction of the government procedural standards for the domestic products, trading products produced by the domestic and foreign enterprises. We are going to do that as well. The second part that we are going to, the 24 action plan is aims to improve the bidding and the tendering system. The first measure is to accelerate the revision of the bidding and tendering law from the legal side to create a more fair environment. The second measure is to focus on recertify a number of the problems reflected by the business entities and break down the unreasonable restrictions that limit equal participation in bidding side. For example, like some restrictions of the ownership on the enterprise's requirement. The third measure is to formulate the rules for the fair competition review in the field of like bidding and tendering, and avoid the introduction of the policy documents that exclude or restrict the fair competition. This is the second part. The third part is that we are going, the 24 action plan aims to on the fair participation in the standardization and the revision to support the foreign investment enterprise to participate in standardization technical committees or relevant standardization organizations, such as in the more star or preferred industries as advanced manufacturing, engineering materials, information communication, under the same constitutions. These are all the industries that we shared that like 10 minutes ago, that we want to open more market access for these kind of special special industries to create more innovation as well. And also the second measure is to timely disclosure of the information on national standards to improve the transparency and openness of the standardization work, and how we are going to make these kinds of like standardizations more open and more transparent. It's also about the timely disclosure by the public, regulated by the public, by the society as well. The fourth part is about building the investment in China brand and strengthening the services for the foreign investment enterprises. We are very famous. Very famous for the investment in China campaign. We are working, promoting some activities on that. And now, currently, it is more popular for Chinese companies to going out and create building companies in Thailand, in US, in Europe, in Middle East, like going out to different places. And we are also still want to invite the companies to come into China to have more investments, One Belt, One Road, and we also publish the 24 action plans to attract more foreign investments. So we are going to create or build the brand, the investment in China. And second part is about make good use of the platforms, such as some enterprise, foreign investment enterprise roundtables. And we want to deepen the regular exchanges with the companies and continuously promote data sharing among the different parties, so that maybe the government, the companies, the societies, some NGO will create some global partnership together to create how can we attract more investment in China and globally work on that field as well. And the next topic we are going to talk about is about safeguarding the IP rights in China. Currently, we have some challenges. For example, it's about the laws infringement and how can we protect on this kind of strategies to make a better IP protection in China. There's also a very famous case that Michael Jordan, the famous NBA star, there's like a when Michael Jordan wants to create his companies in China, he just found that already there are some other companies has already registered the trademark, which creates some impact on his IP application. So it also makes it very important to know about how can you and how can the foreign investment companies to safeguard the IP rights in China, about the laws, about the procedures, and about the measures taken, solutions on that. The very important about the IP and innovation and improve regulations part is also like combined with the 24 action plans. So we are going to strengthen the IP protections. The very important thing is to match the international high standards intellectual property rules to accelerate a national information platform for IP protection, strengthen the protection of the trademarks. As we all know that AIGC is quite popular after the release of the ChatGPT, as almost everyone is using the AI. So how to protect the products conducted by the AIGC is also a very challenging questions, problems, legal issues in China now. So the Beijing Internet Court ruled last year whether the AIGC pictures created by the tools will be protected in China under Chinese law. They ruled that it will be protected. There's a plaintiff. He used stable divisions like a tool to create a picture, and then someone used the picture without his permission, and the plaintiff sued him. And finally, the court ruled in favor of the plaintiff of 500 RMB to safeguard that the plaintiff has the copyright for this picture, although it is created by the AI tools. He also enjoys the copyright for that picture. And last month in April 2024, there's another case about AIGC, the first case about AIGC regarding the personal rights, the right to the voice to the AIGC. And also the Beijing Internet Court also ruled that the plaintiff has the right to the voice. In that case, it is ruled in favor of the plaintiff of 250,000 RMB in favor of the plaintiff. So based on these two, the the first case, AIGC cases in China, we can see the trend that at least in the Chinese government or the court rule systems, we are going to prefer to safeguard the IP products in favor of the creator or the author to protect on that. It is totally different from US, because as the US, US court also ruled a very famous case of the Zhangya of the Dawn. The plaintiff author, he created the comics by Midjourney, and also the court ruled that the comics created by the AI tools will not be protected because this is not created by human. It is more created by the AI tool, so it will not be created. So from different kinds of the jurisdictions in China, we will protect the AIGC. However, in the US, at least for now, the courts tend not to protect the AIGC, IP rights. So sometimes if we are going to define or identify these kind of IP protections, it's better to know more about the IP safeguarding things. And also, for the second part, let's come back to the second part. It's about like facilitating the international business and optimizing the management of the foreign work and the residence permits in China. So we are also going to facilitate the foreign business visas and relax the validity period of the visas to 2 years for the managers and technology peoples of the foreign investment enterprises. And we are going to promote more international flights. And also for the foreign peoples, they will have some more one-pass acceptance and payroll approval platform to handle all these kind of applications, rather than they will go to the authorities for times, come back and forth. And now it's just a one pass, one click, one step to get all these kind of process done by the government. It's like we're providing some convenience and using the technology and innovation things on their side. The third part is that we are also going to support cross-border of the data flow between the foreign investment enterprises and the headquarters and improve the rules. It's also very important that the cross-border data transfer is also very sensitive in China now. And we are going to have some trial and explore a whitelist for the Guangzhou, Hong Kong, and Macau, Greater Bay areas. So the cross-border security management of the data, will have like a new try first within the Greater China areas. And maybe later, after we have a try that, we will have some other tries with the foreign countries on the cross-border data transfers, because we are data areas that we are using the data every day. So it's very important for us to have this kind of cross-border transfer management and also this kind of convenience from the government side. And also the 24 action plans focus on to define the scope of the important data. What kind of the data will be regarded or seen as important? It also will be discussed in the future. And the third part is to fully and deeply in the World Trade Organization e-commerce negotiations and promote the construction of the global digital trade rules, as like we are going in a global supply chain network we are doing business with all the foreign companies. How will we transfer these kind of how can we explore the digital trade rules? Also very, very important. So we are going to have more to speak out at the international platforms to create more convenient and nice policies for other peoples. The last part is about the actively promoting the negotiation and implementations of the high standard economy and trade agreements. So the government actively promote the accession to the comprehensive and progressive Trans-Pacific Partnership Agreement and the Digital Economy Partnership Agreement, and push for the incorporation of some of the high standard economy and trade rules into the arrangement on the establishment of a closer economy and trade relationships between the mainland, Hong Kong, and Macau. And still within the Greater Bay areas, we are going to have some trial on the trade side, on the data flow side, to control and promote these kind of innovations. And for the last part of our today's sharing, we are going to have some talk about the China's labor and employment laws. So we want to ensure the compliance and managing employer-employee relationships, which is very important. For example, the foreign companies, they want to invest in China. Sometimes they will decide to sign the labor contract directly with the subsidies at the host company, maybe just in China. And sometimes they will try to sign an expat contract that the employee will still sign a contract with the home company, maybe Thailand, and then like rotate him to China for 3 years. After 3 years, he will come back to Thailand and work for the same company for the expat contract as well. So basically, no matter what kind of like types or working types they are choosing or defining, the very important thing is that we have to make sure everything is under compliance with Chinese labor law. It's about for example, the recruitment and employment contracts. We have to pay attention on the legal requirements for hiring and drafting the employment contracts. And there are some limitations and requirements on the wages and working hours, and on the annual leaves, on the sick leaves. That we have to go through, and the Chinese law, how it works, and to comply with the regulations on wage payments and the permissible working hours. As the cities differs, like we have the minimum wage payments, like differs from city to cities, and we have to pay attention to that as well. The third part is about the termination and the social insurance. It's also very important to navigating the laws related to the employee termination and the contributions to social insurance. Sometimes we have heard about a very, just recently, Tesla is going to terminate the contracts signed with the graduates, the newly graduates, college students in China, and also create a very publicly heated topic now in China. So they are just signed a contract with the foreign Tesla, a very famous and popular company. And then they just joined the company for 1 month and then got terminated. So how can Tesla or other foreign invested enterprises deal with the terminations? And if the size of the company is very big and creates some maybe some damage to the branding, to the reputation, which is now we want to avoid that. We have to know and make sure in advance that the termination and the social insurance is all in accordance with the Chinese laws to eliminate and mitigate the legal risks as well. So basically, this is my sharing about the investment in China. We shared about the challenges, the opportunities, and some legal considerations from the market access, from the policy efforts that encouraged for the by the 24 points action plans, and for the fair competition. The third part about the fair competition and IP protection. The last part about innovation and the labor and employment. So basically, this will be our today's final the whole sharing on these topics. And last but not least, I want to have some talk and discussions about who are we and what do we do. We are Law Purpose. Law Purpose is a comprehensive, innovative legal service platforms based on the founder team's years of experience in the legal technology and the legal service industry. We provide professional, sound, and convenient services for enterprises with our global network of covering 151 countries and territories, as well as the legal expert resource in various China industry sectors. This is like we are very professional legal service platform, and we have a large and various legal resources across like almost will cover most of the companies in the world, countries and territories in the world, 151. And what do we do? That's also a second part of questions. And basically, we will have some global lawyers recommendation. We will recommend our clients for the global, local platforms like today we are going to have the connections as well. And the second part, we will have some legal research to the different jurisdictions in the world, as sometimes we want to build a company or create some things in China, in US, in German, in Middle East. We all have these kind of different various legal research around the world. The third part is that we have the legal consulting services. We will help you consult and advise on various advices you need when you are going to the when you are going out, no matter where you want to going out on this world, we will provide professional and legal consulting service for you based on the global lawyer network and our research and the consulting professional services. And our service is very we have some services features. We will extend to 151 countries. We will combine with the strategic development with a comprehensive in the industry experts who have both business sense and the legal knowledge as well. We have the one-stop deliveries by a professional team. We will do everything for you, and you will just get a very reliable result, easy for the clients. And caring to the actual demands of the enterprises, we will have the support from Duro teams, and we will have a very nice customer-focused advice and service for that. And the core value for us is to provide the focus on the corporate cover on that. And also to based on the Chinese and global legal resources and to provide a one-step global service as well. We will have abundant legal resources, one-step professional service, and very cost-effective. So we are very great and nice partner for you to provide all the services if you want to go out and come to us. We are law purpose. Thank you.
Thank you very much, Feng and our speakers, for sharing very well presented presentations and sharing some insightful regulation around investment in China, especially the 24 key point action plan. So we are running out of time. We actually received a couple of questions from our audience, but because of the time limitation, I think we will be able to reach out to you via email, and so we apologize if we have any inconvenient cause during these 2-hour live sessions. And before we close, we would like to invite you to send us your feedback by scanning this QR code, and then you will be able to download the full presentation from the FDA and also from the law purpose. And you have our email address on this slide as well, just in case if you have any legal or tax inquiry around Thailand or around China, please feel free to email us. Thank you so much for staying in these 2-hour live sessions. We will see you in future events. Thank you. Bye-bye.